And the judges, whenever they're ready, can introduce themselves.
Good afternoon, everybody, and welcome to the National We the People competition. We hope you enjoy your presentation today as well as tomorrow and possibly on Monday. My name is Dan Taubman, and I'm a senior judge on the Colorado Court of Appeals in Denver, Colorado. I'll ask my colleagues to introduce themselves.
Hi, I'm Ben Glickman. I'm a supervisor with the California Attorney General's Office. I'm also an alumnus of this program. I represented California at the national finals back in 1995. So congratulations on making it here.
My name is Ali Khan. I am an attorney in Chicago. Like Ben, I too am an alum of the program representing at nationals the state of Illinois in 1998. And I know how hard it is to get here. So congratulations again for being here.
Now, we'd like you to introduce yourselves and your teacher as well.
Hello, we are from McKinley High School, and this is our teacher, Mr. Sean Kamita. My name is Emily Kwong, and I am a junior.
My name is Seong Park, and I'm a junior too.
And my name is Ocean Ko, and I'm a senior.
Okay, welcome. We're going to do question one, which I'll now read. Then we'll hear your opening statement, ask you some questions, and conclude with some feedback. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? You may begin.
If American citizens think that certain laws or executive orders contradict the ideas of their constitutional rights, they are allowed to bring their complaints to the courts. Judicial review allows the judicial branch to rule on laws, executive orders, and other actions that are done by Congress and the president. Judicial review has been a vital part of our government system since the early 19th century. Although it is not explicitly stated in the Constitution, declaring laws as unconstitutional is an implied power for the judicial branch. The Supreme Court uses this as a part of checks and balances to make sure that government powers are not abusing their privileges. Also, judicial review of the Supreme Court can overturn state actions, which include laws passed by state legislatures and activities of state executive bureaus. Federalism is where government powers are divided between different levels, like central and state. Anti-federalists didn't immediately accept judicial review because they feared that the Supreme Court would use judicial review to eliminate the power of state courts. The Supreme Court has been overturning hundreds of lower court cases results, but does so by extending civil rights that came out of state actions.
Modern judicial review poses a threat to federalism because it enables the Supreme Court to impose nationwide policies through a majority vote. However, it is only used as a last resort. The Supreme Court keeps each branch of government in check. It serves to ensure that the changing views of a majority do not undermine the fundamental values common to all Americans. An example of how judicial review affects federalism is Roe v. Wade. In 1973, the Supreme Court ruled state laws prohibiting abortion were unconstitutional and that a woman's right to an abortion fell within the right of privacy as protected by the 14th Amendment. This case confirmed that the Supreme Court can extend its jurisdiction to women's reproductive rights cases. Judicial review is a mostly counter-majoritarian practice because it does not always rely on the majority's will. Instead, it looks to the Constitution for justice. Fundamental rights should be protected and be more important than what the majority thinks. However, there can be times when judicial review is not counter-majoritarian and votes in favor of the majority. With that being said, judicial review should be mostly counter-majoritarian because the majority is not always right. For example, during the time of Brown v. Board of Education, many white Americans believed in racism and white supremacy, but the Supreme Court went against that. A unanimous vote determined that separate education facilities are inherently unequal and unconstitutional in the context of state public schools. The judicial branch overlooked popular opinions and considered the founding documents of our country. Preventing racial segregation was protected by the 14th Amendment's Equal Protection Clause. Judicial review should be used for justice and to determine what is right instead of for personal agendas.
Judicial review does not need more limits because the federal judicial system is made up of tiers, which creates a form of just checks and balances. There are district courts and federal circuit courts and the United States Supreme Court. If there's a disagreement with the lower court's ruling, the next level courts will check on it. The Supreme Court provides the ultimate determination if needed. Judicial review can be tricky at times because the results do not always hold true. This is shown through how the Supreme Court is limited by amendments. If a law is passed, but an amendment deems it unconstitutional, the amendment then trumps the court's ruling. That concludes our presentation.
Thank you for your presentation. Could you tell us what the Supreme Court held in Marbury v. Madison and what impact that's had on judicial review?
I'm sorry, could you please repeat that?
Could you tell us about the Supreme Court's decision in Marbury v. Madison and what impact that has had on judicial review?
The decision in Marbury v. Madison was that judicial review, that the judicial branch has the power to judicial review, and that they can rule on laws. They can rule that laws are unconstitutional, and they have some power over they can overturn state courts' decisions.
Okay, thank you.
With regards to the Supreme Court, do you believe that the justices should be term limited?
Sorry, Ocean, you can go.
I'm sorry.
Oh, sorry, no, Emily, you can go first. I'll go after.
I think that the justices do not need to be term limited because when they were being appointed to be a justice into the Supreme Court, they got the approval they were appointed by the president and they got approval by the Senate. So they can be trustworthy.
Okay. Does everyone agree with that?
If the issue with justices being having a limit on terms resides with the reason of how the courts is balanced in terms of their political opinions, I believe that it is important that the justices are vetted to ensure that the Constitution is protected. But also I believe that the current system now is okay because justices don't necessarily vote on issues based on their beliefs. It's based on the Constitution to protect the American people. And an example I believe is that in the recent 2020 elections, especially the case that was filed by the Texas Attorney General about overthrowing the results from other states, the justices were a majority Republican, but the ruling on that case was that it was thrown out.
I also agree with my other members because any justices can be removed or impeached by legislative branch if they make any injustice action.
Thanks. So Does the Texas case that was just mentioned, or any other case, does that show kind of internal limits that the court has placed on itself? What internal limits does the court use to kind of constrain its power?
I'm sorry, could you clarify what you mean by internal limit?
Yeah, so are there policies or doctrines that the court utilizes that limit its own power? In other words, it isn't limited by some other law, but it chooses not to hear cases or chooses to decide cases only in certain circumstances. Are there any internal limits that it's placed on itself?
The most important document when being considered with judicial review is the Constitution. With rule of law, the Constitution is the most powerful power in the government. So when the Supreme Court is doing judicial review, they have to look to the Constitution to determine what is right and what is just.
Okay, what about, like, have you heard of like standing and mootness or the political question doctrine? Have you heard of any of those things? And if so, how do they limit the court's power? Okay. How does the doctrine of incorporation or in selective incorporation, how does that relate to judicial review and federalism?
The selective incorporation is that the states can't create laws that go against the Constitution that are unconstitutional. Sorry, could you please clarify the question?
Yeah, so that's right. So the incorporation is applying the Bill of Rights to the states. How, if at all, does that impact federalism? Does that weaken, strengthen? How does it impact the relationship between the federal and the state governments?
I think that it strengthens the relationship because the states have to look to the Constitution, and that is more of a federal thing.
Let me ask you a different question. Do you think that the process for choosing Supreme Court justices now is too political, with all the Democrats or Republicans voting one way and the other party voting the other way?
I do not think that it's getting too political because, as mentioned before, when appointing justices or voting, there is a system of checks and balances. So even if one part of the government is a majority of something, the other part can check on the other branches.
To kind of add to that question, do you think it's a problem when we can kind of label certain justices as, oh, they're conservative or Republican, or they're Democrat or liberal? You know, is that a problem when we kind of affiliate? No. I think we've hit the time.
And time. Everyone give a round of applause.
Let's show our appreciation for the team.
And feedback from the judges.
Sure. Thank you for your presentation. We appreciate your sharing your thoughts about the important question of judicial review. I like the fact that you mentioned it in your opening statement that judicial review is not mentioned in the Constitution, but that it's an implied power. You might have mentioned the case of Marbury v. Madison. where Chief Justice Marshall wrote the opinion saying that the court has the right of judicial review. And I like hearing your thoughts about the different views from the Federalists and Anti-Federalists about judicial review. That was good. And that your views that generally the Supreme Court is counter-majoritarian because its decisions will protect minorities. I think that you might have provided a little bit more information in answering questions like the different limits on the jurisdiction of the Supreme Court, or the limits on what the Supreme Court does, because there are certain cases where the Supreme Court decides not to hear a case because it's a political case, or because the case has become moot because it's no longer a controversy. So those are things that you might have added to your presentation. But overall, I think you had a good idea of the issues surrounding judicial review, and we appreciate your presentation this afternoon.
Just, I think my colleague said a lot of it. So again, first of all, thank you very much for your time, and congrats for being here. Again, it's not an easy thing, a lot of hard work. So, and I've been on the other side, so I know how it feels. I would add just to that briefly, just when you answer questions, just give some more concrete evidence, build upon your answers. Like when I asked the term limit question, perhaps you can acknowledge why some people support term limits in your answer. Some people support term limits because of X, Y, Z, but this is why, I disagree. And, everyone can feel free to jump in, feel free to disagree with your colleagues. Those are the biggest things I would say, right? Everyone just kind of be enthusiastic about that. And I think that's, if you can kind of do that going forward, I think you'll find it an even more engaging conversation. But again, congrats on being here.
Yeah, I would echo what's been said so far. I thought the prepared remarks did a pretty good job of answering the question. I like the history of how it's an implied power, what the anti-federalists were concerned about, how it poses a threat to federalism. I thought all of that was well done. And the Roe v. Wade example I thought was appropriate. I thought the part I liked the best perhaps was when you were talking about the counter-majoritarian issue, and you said something along the lines of, but protecting fundamental rights is more important than majority rule. And I think that is, in a nutshell, the justification for a counter-majoritarian court, an unelected court that is able to overturn legislatively enacted laws, is that they're doing so in the name of protecting fundamental rights, which in and of itself is a core democratic principle, right? So I appreciated that. On the questions, we struggled a little bit. I think you know more than you let on based on your presentation, and so I think I would encourage you tomorrow to not be shy about what you know, and go ahead and put yourself out there. And if it's not what the judges were looking for, they'll redirect you. But I think you knew what selective incorporation was, or I think standing in those kind of doctrines, or at least you could have made an effort at it. And so I would just encourage you to do that. You're the experts in this. You've been working so hard, and it shows. And just let that show throughout the presentation. So good luck tomorrow.